Hey everyone, and welcome to This Explainer. Today we're diving into something truly fascinating. We're going to explore how a seemingly mundane business disagreement over, of all things, a tea permit, ended up putting an entire nation's legal transition to the ultimate test. It's this wild story of shifting political eras, the massive weight of a brand new constitution, and a legal paradox that literally had to be solved just to keep a country running. And all of this profound legal philosophy? Yeah, it all started over some tea.
I know. It sounds completely absurd, right? But I really want you to keep this specific question in the back of your mind as we go. Can a dispute over a tea permit actually unravel a nation's legal system? To find the answer, we are diving deep into a landmark 1996 South African Constitutional Court case.
All right, let's start with the ground-level dispute here. On one side, we have Ynuico Limited, which was a company that supplied tea and simply wanted to import it freely from foreign sources. Makes sense, right? But on the other side, we have the Minister of Trade and Industry. The minister had set a rule, this was based on a 1988 government notice, that forced merchants like Ynuico to buy a pro-rata percentage of local domestic tea before they'd even be granted a permit to import the foreign stuff. Well, Ynuico was refused their permit, and they decided to fight back.
Section 1. A question of power.
So what started as a frustrated business owner just trying to bypass a trade hurdle quickly blew up into a massive constitutional attack on the very nature of the minister's power. You see, the authority to block Ynuico's tea didn't just come out of thin air. It came from an old law, specifically Section 211B of the 1963 Import and Export Control Act. This law stated that the minister could restrict imports whenever he deems it necessary or expedient in the public interest. I mean, really think about that wording for a second. It is incredibly broad. It gave the minister almost limitless discretion to just decide what gets imported and what doesn't.
But here's the catch. By the time this case actually reached the Constitutional Court in 1996, South Africa was operating under a brand new democratic interim constitution. Ynuico pointed directly to Section 37 of this new charter, which explicitly states that the legislative authority of the Republic vests in Parliament. Ynuico's main argument was simple, but honestly, explosive. Under this new constitution, only Parliament has the power to make laws, and they absolutely cannot surrender this supreme power to a single solitary minister. And this perfectly illustrates exactly what Ynuico was arguing. They claimed that the old 1963 law was essentially giving the minister carte blanche, or plenary legislative power. It's literally like handing someone a blank check with zero objective guidelines or criteria. Ynuico argued that allowing a minister to have this kind of unchecked power over import rules completely violated the strict separation of powers required by the new constitution.
Section 2, the Constitutional Time Paradox.
So, listening to all that, it sounds like Ynuico has an airtight case, doesn't it? Well, hold on a second. The court, led by Judge Didcot, identified a massive chronological hurdle in Ynuico's argument. Look at the timeline. The Import Act giving the minister power was passed in 1963. The specific notice restricting the tea was published in 1988. But the new constitution, with its strict rules about Parliament making the laws, that didn't come into effect until April 27, 1994. The delegation of power and the actual tea restriction happened long before the new constitution even existed.
To really grasp why this timeline matters so much, we have to contrast the two eras. The pre-1994 Parliament operated with absolute unchecked legislative sovereignty. They weren't subject to constitutional discipline at all, meaning they could, and frequently did, hand out these blank check plenary powers to ministers like candy. But the post-1994 Parliament is a completely different beast. Its power is strictly bound and regulated by the new constitution.
So the absolute crucial takeaway here is this. Section 37 of the new Constitution is written entirely in the future tense. It deals with how laws are made from April 27, 1994 onward. As Judge Didcot pointed out, it simply cannot retroactively apply to a defunct pre-1994 Parliament that was already dead and gone by the time the Constitution took effect. Ynuico was basically trying to use a brand new rulebook to penalize a game that ended years ago.
Section 3. Preventing legal chaos.
Because if you really think about it, this timeline creates a frankly massive problem. If the old Parliament made thousands of laws using rules that would be totally unconstitutional today, do all those laws just suddenly disappear? The architects of the Constitution actually saw this exact problem coming from a mile away. That's why they included Section 229. This section is the ultimate pragmatic solution. It basically says that all old laws remain in force unless they're repealed or amended. Think of it as a legacy mode or, an emergency operating system patch for a transitioning democracy.
Why was this legacy mode so absolutely essential? Well, the court explicitly warned that dismantling all old statutory law in one fell swoop before anything new had been written to replace it would result in total catastrophe. We're talking immediate chaos in government, a complete collapse of administrative functions, and a breakdown of the country's economic infrastructure. You just can't delete a nation's entire legal code overnight and expect things to be fine.
And Judge Didcot captured the court's pragmatic reality perfectly with this honestly incredible phrase, swallowing the camel of illegitimate origin to avoid straining at the gnat of unbridled delegation. What he meant was this. The framers of the new Constitution had already accepted the massive, very uncomfortable reality, the camel, of keeping laws made by an older parliament that was elected undemocratically just to maintain stability. If they could stomach that huge flaw, they certainly weren't going to panic over the much smaller flaw, the gnat, of a minister being delegated a bit too much power back in 1963.
Now, what's really interesting here is that these preserved laws aren't just immune forever. Section 229 starts with the phrase, subject to this Constitution. This means that if an old law directly collides with the fundamental rights entrenched in the new Constitution, the new Constitution wins hands down and the old law is struck down. But, and here is the kicker for our dispute, Ynuico had actually abandoned their arguments about fundamental rights super early on in the case, so there was literally no direct constitutional clash left to strike down the minister's power.
Section 4. The final verdict. Okay, so with their main arguments rapidly unraveling due to the whole timeline issue and the sheer necessity of keeping the country running, Ynuico's legal team tried one last desperate maneuver. They posed this incredibly strange argument. Since the new post-1994 Parliament hadn't repealed the old 1963 T law yet, didn't their silence basically mean they had adopted it? They argued that this acquiescent silence was effectively the new Parliament validating the old law.
Judge Didcot's response to this was brilliantly blunt. He stated, "A positive decision gets imputed to Parliament in ignorance of what it would have actually decided. The notion is untenable." He completely, 100% dismissed the idea. You just cannot equate a total lack of parliamentary debate, a lack of legislative proposals, and a lack of voting with actual legislative action. Parliament's silence, it's just silence. It is absolutely not a law.
So let's see how all this builds into the final picture. It's kind of like a giant puzzle. Ynuico argued the minister had a blank check. The court said, well, the rules against that only apply moving forward. Ynuico argued the old law violated the new Constitution. The court pointed to Section 229, which preserved old laws to stop total societal chaos. Ynuico argued Parliament's silence meant they adopted the law. The court firmly stated that silence is not a legislative act. The court systematically dismantled the applicant's entire case piece by piece.
And so, we finally arrive at the concrete outcome. The Constitutional Court laid it down. Section 211B of the old Import and Export Control Act was perfectly valid and not inconsistent with the new Constitution. And for Ynuico, yeah, it was a rough day. Not only did they not get to import their tea freely, but they were also ordered to pay the costs of the proceedings.
Before we wrap up, I want to leave you with this final provocative thought. How do transitioning democracies balance the lofty, perfect ideals of a new constitution with the messy, practical reality of keeping a society running day to day? The story of Ynuico Tea Permit really proves that nation building isn't just about writing perfect new laws, it's also about figuring out how to survive the old ones. Thank you so much for joining me for this explainer. I really hope you found it as fascinating as I did.